Kevin Hunter with Jeff O'Brien on the Business Forum Show, and we're talking about buying a business today. So there's a lot of different things to take into consideration when you're buying a business. How structuring the payment so you can actually afford to buy it. There's non-compete issues. And one of another area, transition assistance. I think of this in many cases. I have visited with business owners that talk about, hey, I'd like to just jump in and start running the place. And I know many clients that their business would stand to lose probably 25-30% of their clients if the existing business owner just walked away, because they're doing business with that company because of that person. So there's a lot of different issues. So let's kind of start in the beginning here, Jeff. Let's talk about some ways that you can structure the payments so you can actually afford the business, the importance of that.
Well, there's two different ways, really. There's a lot of folks go to a bank and get financing, and there's conventional financing programs as well as the Small Business Administration, the SBA type loans that might be available, and that's one way of doing it. The other is to have seller financing. If the seller is willing and able, the seller may be willing to finance all or a portion of the purchase price. It may be a way for the seller to get more than what they would get if the bank was just financing it and the purchaser was handing them a check, so they could be able to do a promissory note with maybe 6 or 7% interest and be able to make more on the business than otherwise by financing it themselves. There's certainly more risk in that for the seller, because if the buyer defaults, then the seller's out a portion of the purchase price, but that is one way to do it. And if from the buyer's perspective, it depends on what they qualify for. I'm more of a proponent of getting a loan from a bank, whether it be conventional or SBA, and just paying the seller so that issue is resolved, rather than continuing to owe money to the seller. It's always, in my opinion, it's always easier to deal with the bank in terms of loan covenants and things like that than just a party who's not in the business of lending money.
Right.
But in the right circumstances, it does work. And then if you get into where there's part bank financing, part seller financing, that gets a little more complex in terms of security interests and subordinated interests and all that kind of stuff. So that's financing. How you pay for it is a key issue in terms of buying a business.
I was actually visiting with a business owner who was obviously doing seller financing. Somebody else had bought their business, and she had done seller financing. I was really kind of blown away by how much she had to say about how this ought to be done and that ought to be done and everything else. I was really going, wow, I don't think I would want to be the person, having bought your business from you, with all this, contingencies and everything else that was involved in it. It appeared to me to be very messy. So at least in that situation, I could see exactly why, if I was the buyer buying a business from her, I would have wanted to finance at a bank and get her out of the picture altogether.
Yeah. And, when you're dealing, the financing issues comes up some of the other issues. You're going to want to do, typically you'd sign up a purchase agreement, and, we'll talk in a minute between asset versus stock sale, but you'll have a purchase agreement, and then you'll do due diligence, and you'll look and see if are there any liens on any of the assets and the equipment, on anything like that. Because, of course, especially if you're going to be dealing with the bank, those liens are going to have to be satisfied prior to closing. If I'm representing a buyer, I want those liens satisfied, period. So there may be, if you're doing seller financing, there may be enough of a down payment that has to be made in order to have those liens cleared up, and then have the seller finance the balance. That's going to determine how it's financed as well.
So let's talk a little bit about this asset versus stock sale. What's the difference? What are some of the things involved here?
Well, there's a couple of key distinctions. An asset sale is where the buyer is buying the assets of the business, buying the equipment, the inventory. It could be trade names, intellectual property such as trademarks or patents. Maybe accounts receivable, maybe not. And maybe, and assuming minimal liabilities, maybe leases, and that might be it. Or, equipment leases and property leases. Other than that, all the liabilities stay with the seller. Again, hence why you have to clear liens out before you close. And I would say 90% of business sales these days are that I handle at least are asset sales.
Mm-hmm.
A stock sale is where you're selling the stock of the company to new owners. And with that goes all assets and all liabilities.
Mm-hmm.
There are business reasons for doing it. I'm working with a client right now where it was for non-legal reasons in their best interest to structure it as a stock sale.
Mm-hmm.
So there are circumstances that do merit that do warrant a stock sale. So that's key is terms of it really comes down to cutting ties with the liabilities of the existing business. An asset sale, that's going to happen.
Mm-hmm.
Subject to any kind of agreement to assume certain liabilities
Sure.
that are needed to continue operating the business. With a stock sale, you're taking everything, warts and all,
Mm-hmm.
when you buy the stock.
Mm-hmm. So let's visit a little bit about non-competes and the importance of those, because you're buying a business from somebody who obviously has a lot of capacity to go out and do this again if they wanted to.
That's correct. And we've talked. We talk about employee issues and non-competes. The public policy doesn't always favor non-competes in that context. When you're talking about somebody who's selling their business, the courts are much more lenient, much more in favor of enforcing the non-compete under the policy of someone shouldn't be able to sell their business for a handsome chunk of money and then go down the street and reopen it and take all the customers. So whereas you might get away with 2 years in an employee context, you might get 5 years with a sale of business context. But the idea is, if a certain amount of the business is going to be goodwill, especially if it's a service business, and if that person is competing with you, then why the purchase would be of no value unless you had that agreement not to compete as well. Which then, of course, you may also want to have some assistance from the previous owner. That it might be a trade-off. Okay, you'll give me a non-compete, but I'll keep you on as a consultant or an employee for 6 to 12 months to help
ease the
transition. Now you have to be careful with that, because obviously this is someone who has run the business, that owned the business, and if you have other employees there, you're going to have some questions about who's in charge. So you want to have
Do I ask you?
Yeah, you want to minimize. You want to have maybe as short as possible of a transition period. So 6 months might be better than 12 months. But that's a good way of one of those compromises of, okay, I'll pay you for a little bit, maybe even a little bit more than you otherwise get for this business, but you're also at the end of the day not going to compete against me for a period of time too.
Kevin Hunter with Jeff O'Brien visiting about buying a business here on the Business Forum Show. You can contact Jeff O'Brien at jobrien@loman.com. Again, Kevin and Jeff here on the Business Forum Show. Thanks for listening.